Hello, welcome back. GovDoc Breakdown, no opinions, just facts and summaries of government documents, and you do the rest. June 5th, Supreme Court opinion, BLOM Bank v. Honickman. All right, finally back to actual cases heard by the Supreme Court. This isn't an order, this isn't an opinion on an order, an actual case. So let's get into it. BLOM Bank is a Lebanese financial institution, and in this case, they are being sued by the victims and families of Hamas terrorist attacks. Not the most recent Hamas terrorist attacks, but attacks that took place from 2001 to 2003. These attacks took place during the period known as the Second Intifada from 2001 to 2005, where there were multiple bombings and other attacks targeted at civilians. So the victims and families in the U.S. are suing the Lebanese BLOM Bank, claiming that BLOM Bank helped fund terrorism by providing financial service to people affiliated with Hamas. Now you might be asking, how are these U.S. citizens suing a foreign financial institution? That's what I asked, basically. And this is where we get to the Anti-Terrorism Act, ATA, which allows victims of terrorism to sue entities that knowingly assist terrorist organizations, even if they are not located in the United States. Plaintiffs, those doing the suing, must show that the defendants, in this case BLOM Bank, were generally aware they were helping terrorist activities. Okay. Now we get to the courts. In the district court, BLOM Bank asked to dismiss the case, saying that plaintiffs didn't provide enough facts to show the bank knew it was helping terrorism. Now this is where we get to the eventual issue being addressed by the Supreme Court. The plaintiffs were given multiple chances to improve their complaint in response to BLOM Bank saying they did not provide enough facts to show they were aiding terrorism, but they did not take the opportunity to do so. They said, this is it, this is our case, we don't want to change it. The district court eventually dismissed the case with prejudice, meaning permanently closing the case and saying it cannot be filed again based on the same facts or claims. The district court also refused to let them revise the case because they had chosen not to add new facts earlier in the case. Then we get to the circuit court, remember district court, circuit court, Supreme Court, which ruled that the district court did use too strict of a definition for what general awareness of the possible aiding of terrorist activities means, but even under the correct definition, the circuit court said the plaintiff's facts were still too weak, so the dismissal stood. After losing the appeal, the plaintiffs then went back to the district court and said, okay, so the circuit court said that you used not the right standard or definition for general awareness, so let us fix our complaint and try again under a legal rule called Rule 60b-6.
Full video located on our channel.